Hello everyone, I hope you're doing great. Well, today's video is about damages and contracts. So to start with, I'll quickly take you to one of the tragic incident which happened a couple of days ago at Francis Scott Key Bridge in Baltimore, Maryland, US, where a cargo ship which was uh, which was supposed to pass through under the structure of the bridge went berserk and out of control because of technical reasons, and it rammed in one of the pillars of the bridge, resulting in the bridge coming down, and as a consequence of the whole bridge collapsing and the tragic loss of 6 lives. Now, if we see this particular incident from the prism of contract law and contracting, there are certain takeaways. There are certain things which are definitely an import, which we can which I'll try and bring it out over in this particular video. So as you know, that this particular bridge is actually owned and managed by was owned and managed by an arm of the government, Maryland Transport Authority, and underneath that, the waterways would have been under the control or owned by Maryland Ports Transit Authority, if I'm correct, and then within the on the bridge there would be different kind of utility companies and the insurance company insuring the bridge, and reinsurance companies and the insurance companies for different ships passing underneath that, and then the traffic and the various car insurance companies. So as you can see, there is a cobweb of different insurance companies, different different parties, and their rights and their subsequent claims. So if we kind of drift from that point and we come towards the world of contracts. So as you know that, as I use the word damages, so at a very broad level, what is damage? That damage is something where what happens as a consequence of a particular breach, what a party is supposed to do in a general course of the contract, and when it doesn't perform that service, and that is what we consider as breach. Now, breach can be because of three different reasons, like misperformance, malperformance, and non-performance, where mal is where there is criminal intent or malice, and non-performance is because of the abdication of the of the responsibility of rendering the services, and then there is misperformance where the performance was not up to the mark because of the lack of knowledge and skills related. But again, coming to the point of damages, within the realm of damages, there can be there are many kind of damages, like general damages, nominal damages, punitive damages, consequential damages, something which I'll delve a bit more in detail, and then there are liquidated damages, expectation damages, and compensatory damages. All these damages sit under a particular premise of whether they have been quantified or they have not been quantified. And what can be quantified is something what we can foresee or what has been written in the paper. So anything which we can foresee, the onus is upon the contracting parties to execute that. I mean, to codify it on the contract paper. Essentially, what happens that in the world of contracts, that there are boilerplates, and then there is the technical section. Now, the technical section is all immensely technical, and it keeps on evolving. But unfortunately, the boilerplate, so to say, remains one fossilized kind of element. So, like we say, that there cannot be one size which fits all. So, in case of damages claim, we need to ensure that whatever is written in the contract is up to date, and the breaches are rightfully quantified, and quantified to the highest degree, where if this particular contract lands up in a court of law, then the court appreciates the fact that the parties or the claimant had taken pains in putting down all the various scenarios of breach, and this is something which happened outside, which could not have been reasonably foreseen by both the parties, and hence the aggrieved party is entitled to consequential damages, something which I said a couple of seconds ago. So, consequential damage is something which happens as a consequence of the breach action of the breaching party, and that is something which is in the realm of unknown unknowns. So, what is unknown? Essentially, we cannot say that everything is unknown, because any company when it's growing on top of its knowledge curve should be is expected to understand that, okay, the way I executed a contract maybe 5 years ago, and what I executed 2 years ago, and what I'm executing now, I am getting more aware, more knowledgeable about the possible scenarios of breach, the possible scenarios where the contract genuinely resembles the real world situation, and only then we are doing, as a company, we are doing a great job in quantifying our risk, and identifying our risk, and then the other arms of the contract, like the most important one is limitation of liability. So, unless and until if the parties, or if the contracting parties, are not quantifying and codifying the risk properly, and assigning a commercial liability to that, then without that, it won't hold much water. So, what happens generally in most of the corporations, that the companies tend to put a kind of a hazy number, they have a mathematical approach, or kind of a reactive approach, or one size fits all approach, whatever you want to say, that okay, the maximum amount of damages claimed would be 5x of the contract amount, of the order amount, or 3x or 10x, or maybe in certain cases a hard coded number is there, like 5 million, 10 million, 20 million. But unless and until the breaches are not identified properly, and the risk document is not up to date with various scenarios of breach, then then the contract is left to the mercy of subjective interpretation of the litigators, or of the court of law. So, that is where this thing is important. And once the risk identified, then the limitation of liability is we would be having taking a scientific approach in fixing up the limitation of liability cap, and as a consequence, then the insurance in a contract would also be quantified as a consequence of that, and then as a consequence of that, indemnification and representation and warranties and those kind of sections will kind of make better sense. Otherwise it's a dark room where we just close our eyes and say that okay, 5x the amount, and then in certain mega mishaps like the one which I started my video with, mega mishaps in maybe like data breach or privacy breach, or there's a massive security or incident or malware breach, we often get caught napping, and that is what essentially the technology contracts and even the other manufacturing contracts or oil and gas contracts need to be aware of. That the more we keep on evolving our contract paper and our risk identification, the lesser would be the scenario of, like I said a couple of seconds ago, the lesser would be the scenario of subjectivity once the contract lands in any arbitration forum or in a court of law, and the parties would be less susceptible to any kind of class action or things like that. Well, this was it from my side, and do let me know how you like the contents of this video on damages and the evolution of contracting over a period of time. And I'll look forward to meeting you in another video. Till then, take care, and I'll see you again. Bye bye.